Mr. Dulos that he would never have a relationship with the children again. If in fact she was seriously ill or believed herself to be seriously ill, that would be supportive of that theory. This theory is supported in part, and I'm mindful of the requirements to make a prima facie showing under such cases as State v. Esposito. This is consistent in part with information that we learned in the family court that I am not at liberty, given current family court orders, to put on the record at this time. But we believe that that evidence, together with evidence we are aware of in the family court file, would be sufficient for us to raise questions about her stability, her state of mind, and the extent to which she was willing and able to go make through on dire threats that conveyed to Mr. Dulos that she would do anything necessary to make sure he never saw his kids. Don't know what these records are. We believe that given the billing information we have, we know that the custodian is in Connecticut, rather. And so we have jurisdiction over that person under our current discovery. We would propose that you order them to provide the records, that they come to you in camera, and then you determine whether we can get the identity of the providers in New York. At that point, then we'd have to resort to interstate process to try to compel production of those records. So we're not asking that the records be given to us. We're asking that they be given to you so you could determine whether we get them.
Just briefly, Your Honor, counsel talked about Esposito in the cases and the follow Esposito. They talk about no fishing expeditions. This is exactly what this is. It's a fishing expedition to determine what these records are. There has not been, if you're going to use the Esposito standard, there has not been a showing to indicate that this is more than a hunch on the defendant's part to gain actually even the court to have access to look at these records. So I'd ask that you deny the defendant's request.
More than a hunch, Judge. Most of us go through a lifetime and don't accumulate those sort of medical bills. This is in the 2 months before she's disappeared. I reiterate what I said in chambers. To date, we have not been provided with one iota of evidence that we can actually review and see ourselves that supports the wild speculation that the state is engaged in here, that she was murdered. She's gone. We don't know why. And I think we're entitled to discover information that leads us to those answers, especially given the state's refusal to provide us with any information about what it's, it says in its warrants there was evidence of a violent struggle in New Canaan. I'm not required to take at face value that warrant. I have a responsibility to Mr. Dulos to test the state's theory of the case. If they give me nothing, I've got to go somewhere to get something. I've made application for material in this court. The state's not responded yet. I'm not going to sit idly by while the state blows hundreds of thousands of dollars in the futile effort to prove that Mr. Dulos is a murderer. He's not. And I am entitled under the Sixth Amendment to develop alternative defense theories, and that's what I'm doing.
Doesn't justify a response.
Well, Attorney Pattis, I don't think, given the state of this record, you've sufficiently shown enough of a basis for the court to grant this motion. I think it is speculative at this juncture. I will deny your motion for order without prejudice. You may renew it if you believe you can develop sufficient facts for the court to grant it.
If, in fact, the family court study surfaces, Judge, in some form that I can have access to, I will renew the motion at that time.
We have motion for return of seized property.
We have an agreement on that, Judge.
There were two, Your Honor. One's
that's the one I referenced to. I misspoke. Yes, there's
one filed on June 13th and the other filed on August 5th. I don't know which you want to address. I mean, basically, the June 13th covers a Ford Raptor, a Chevy Suburban, Cherokee, a server, a MacBook, other computers, 2 iPhones, a hard drive, 2 external drives, and personal papers. I had spoken to counsel, and he indicated that he would like some of the vehicles returned, and I'm willing to, if he's willing to stipulate secondary evidence with regard to 2 of the vehicles, we could probably make that happen. As to everything else, I don't know if he's pushing that or not, but the state would object to anything else being returned.
And which 2 vehicles, please?
That would be the Chevy Suburban that was in Mr. Dulos' care and the Jeep Cherokee, those two vehicles, Your Honor.
Attorney Patterson?
We would stipulate the secondary evidence as to the Cherokee and the Suburban. We understand that the state continues to attempt to develop evidence from the Raptor and make no claim as to that. As to the electronic items, I'm at a loss. I've been provided with no discovery about the electronic items, zilch. And so the state sat on them now for 10 weeks or however long this case has lingered and is telling me my client can't have his effects back because we're not done with them, but we can't tell you what we're doing with them, and we're not going to share with you what we've done. I mean, at some point, it begins to feel a little bit Star Chamber-like and inquisitorial. We have a Fourth Amendment that talks about reasonable searches and seizures. I understand the law enforcement and investigative privilege, but the fact of the matter is the Fourth Amendment uses the word reasonable for a reason. And that is the state doesn't get to do whatever it likes for as long as it likes and say, yeah, you Lukey, you don't get anything, we're privileged, we're the state of Connecticut. This is Fotis Dulos, he's got constitutional rights and we want vindicated in this case.
Counsel, I assure you I'm here to protect the constitutional rights of all interested parties. What's the state's position with...
Judge, if I may, we did discuss these motions in chambers and kind of the backslap I just received with Attorney Pattis. In chambers, it was my understanding that he wasn't going to address any of these issues, so I don't know if this kind of dovetails into my motion to gag, and we'll deal with that. But these type of comments that are made constantly extrajudicially